There's brand new reporting in the New York Times this afternoon about the turmoil inside the Department of Justice when it came to that failed attempt to indict 6 Democratic lawmakers who released a video reminding the men and women of the military that they do not have to obey any illegal orders. According to that reporting in the New York Times, in mid-January, the inquiry into the lawmakers had no sense of urgency, and that when lawyers for the lawmakers were contacted by federal prosecutors, they were not told of any law that had been broken, according to 6 people familiar with the matter. Times goes on to report that everything changed 2 weeks later when, quote, Jeanine Pirro abruptly instructed her team to seek an indictment of the lawmakers. Her prosecutors then faced a decision that many in the department under Trump have confronted: comply or resist. They chose the first. That attempt to indict, of course, failed last week, but as the New York Times notes, it stood, quote, as an example of the chaos that has roiled the department as it has grappled with the president's increasingly erratic demands, even in the face of little evidence. I want to bring in New York Times investigative reporter Mike Smith, who's bylined on that reporting we read from. Also joining us, former acting assistant attorney general for national security at the Justice Department, Mary McCord. Mike, first take us through what you and your colleagues are reporting today.
Basically, what we're trying to show is that when this investigation started, these prosecutors reached out to the defense lawyers for the 6 lawmakers and said, look, we're in the early stages. We're not even sure if we're in the first inning yet. We're not even sure what law we're investigating this under. We're not even sure if it's an investigation. Could one of the lawmakers come in and talk? Would one of the lawyers want to come in and talk to sort of get this thing going? That is as informal a way of starting an investigation as possible, especially after the President of the United States has called for them, essentially called for them to be investigated for this and raised the possibility that they could be punished, up to,
seditious
conspiracy and execution. So it had a very, very informal feeling to it. And within 2 weeks, there was a prosecutors before a grand jury trying to indict them. Like, that is just such a highly unusual, irregular, way for a department to operate, especially on political, opponents of the president and appointees. And look, we're beyond obviously the point of trying to compare this to previous Justice Departments, but the idea, of a previous Justice Department looking at a member of Congress, there'd be all sorts of memos and back and forth up and down the chain about what to do and, how would this survive on appeal and what are the Article 1, issues here and such.
11 secret hearings before Judge Beryl Howell about the crime fraud. I mean, to your point about how this should be special, I guess my question to you is if you compare it to the Eric Adams case, when that was brought to very conservative prosecutors in the New York U.S. Attorney's Office, they marched out. They marched out confidently. Danielle Sassoon basically told Emile Beauvais to shove it where the sun does not shine. Did anyone resist, or is there no one left like Danielle Sassoon?
No, these prosecutors went and tried to bring a case before a grand jury.
They tried to indict the 6 lawmakers.
They tried to indict
just to do it slowly?
And it's not that they tried to do it slowly. They moved swiftly. So they started slowly, and then something changed.
What changed?
We don't know.
Did Trump call and say indict them?
We know as much as we wrote today, which was that, Judge Jeanine told the prosecutors to go and seek the indictment of it after the case had started in a very, very informal way. So you're going from 0 to not just 60, 0 to very, very, very fast, extremely fast. And those prosecutors went in and the grand jury came back and swiftly said no. And that was it. The thing that I wonder in the evolution of the Trump Justice Department is that instead of quitting, is this the next way
of failing?
Just failing.
Just quiet quitting.
Just quiet quitting. And, a very prominent litigator, someone who has been opposing the government in court on a lot of this stuff, said to me that what they wonder on a lot of the things at the Justice Department is their pocket vetoing going on.
What's that mean?
There's are prosecutors being told to do things and not doing them or tanking them. And I'm not saying we have evidence in this case that they purposely went in to tank it, but if you're a prosecutor and you have decided that you believe in the Trump Justice Department and you want to work there, is it easier to just go to the grand jury, seek the indictment, and blame the rigged system than it is to stand up, say no, and quit.
Mary, this is your old office. This must crush you, both the failures and the corruption. Your thoughts on this reporting?
Yes, well, it is pretty remarkable, and it certainly seems like there was some sort of phone call made, a directive that either came directly from the White House or potentially from the Attorney General's or the Deputy Attorney General's office to Jeanine Pirro to speed this up. But, to Mike's point about prosecutors going forward, and he can please correct me if this is wrong, but the reporting I have read were that the two prosecutors who went into the grand jury, these were not career prosecutors in the DC U.S. Attorney's Office. One had been a longtime assistant district attorney in Westchester County up in Connecticut when Jeanine Pirro was there, and she had worked with him and is now apparently a dance photographer. Well, now I guess he's a special counsel to Jeanine Pirro. And then another was a longtime Republican staffer who had almost no prosecutorial experience and also now is a special counsel to Jeanine Pirro, the U.S. attorney. So this seems to me, unless that's wrong, like a case that was never really even given to the career prosecutors or was given to them and they said, no, thank you. And so I do think that might have something to do with why these two were willing to go in on such a completely not just baseless, but it would be unconstitutional to indict these 6 members of Congress for conduct that is clearly protected by the First Amendment and, as Mike said, raises serious speech or debate issues given their status as members of Congress. And I would refer us all also to Judge Leon's decision in the case that Senator Kelly brought against Secretary Hegseth to try to prevent the demotion in rank and pay. And Judge Leon, in no uncertain terms, said this flagrantly violates the First Amendment. This was First Amendment retaliation, and you don't need a weatherman to know which way the wind blows. And I'm glancing over to make sure I get the quote right. So, it's not just me saying this would be unconstitutional, but, to try to retain, now that was, of course, not a criminal prosecution, but still this type of retaliation for First Amendment protected speech, especially by elected officials who are elected in order to speak on matters of policy. It's really outrageous. I can't imagine a career prosecutor in that office taking this to the grand jury.